story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Frankie Rose's Think Tank. Here's your host, Frankie Rose.
Hey guys, well, there's stuff happening in the jury room, so I thought, you know what, we'll watch. So it's just the jury was asking questions, and they've been answered, and the lawyers were just brought up. They had a sidebar, so we're back to waiting. So what I thought we would do, hey Jessica. So what I thought I would do is go back a little bit and listen to what happened there. I don't want to go too far because I think this is coming close. Hang on here, we'll get there. Okay, there we go. Yeah, that's a good question. I know, I agree with you 1,000%. Look at the shape that Richard Allen is in and what happens in that case. Talk about shackled. Hey, Jessica, do I think she should be charged? What do you guys think? What do you guys think? Do you know what? I am so on the fence with this. I really am. Literally, there's different laws here in Canada than there is in the US. So for me, I'm just still pretty much in shock that, a 15-year-old can go to a gun range and use these weapons. It's all kind of surprising to me. So this here is going to be the last question that they had for the jury, or sorry, for the judge. So this is the second time that they've come in with questions, and it's interesting. It's basically coming down to they want to know about charges in a little bit more detail. So I don't know. What do you guys think? I feel like if they knew what he was doing, they should be charged. I can agree with that. You betcha. How do you guys feel though about 15-year-olds being able to use these large guns at like a target practice range? They bought an underage child that was struggling a weapon legally. He can't have one, and it was not secured. It had something to do with a couple of the charges that have been pressed. So I think they're just trying to decide exactly what they're most comfortable with. Where they're waiting right now, they're just waiting for the judge to come in. And then after that, we'll see. We'll also see the Jennifer Crumbley. She comes in. They have a little bit of a discussion about these laws, and then they went back. So that's just basically what we're watching. And the other one was basically on the different laws as well. We have our conceal and carry, and I feel like they're okay at ranges if your child is 18 and no. Yeah, that's what I'm thinking. Like, isn't that a little bit young to be able to play with like a 9mm? You know what I mean? Like, oh my word. Let me see here. So nothing is happening at the moment. So yeah, we'll just watch this for a few minutes. I agree. Oh, that's a really good question, friend. What do you think the verdict will be? I mean, I honestly have no flippin' idea. Based on the questions, it looks like she might get charged with a few of the different things, but they're still trying to figure out which charge is the most suitable for this occasion. I don't see anything wrong with taking a reasonable teen out to practice. They thought he may have committed suicide. That leads me to believe they were aware he wasn't well. Yeah, yeah. Um, was he threatening to commit suicide after this happened to his parents? For some reason, I had that thought in my mind. I'm sure I've got the volume on. Yeah, I do. They don't. I thought in Michigan you don't have to lock them. You see, these are things I don't know. With all these different states, our laws are like nationwide, and yours is a little different where they are state by state in a lot of cases. Why don't they ever show the dad? He's going to have his own trial. So yeah, that is boom. That's the reason right there. They've talked about him a couple of times. The defense has, and putting a little bit on that. So I can't 100% say I know. I mean, Ethan said if they called him that they would plead, he would plead the fifth. So he certainly doesn't want anything to do with helping his mother, does he? Okay. Oh yeah, she's changed lots, Jessica. Laws to secure or not, it's common sense in my mind, in my opinion, regardless. Like I say, we don't have them. Hunting, we've got stuff for hunting, but yeah, you definitely have to have like a permit and you have to have training. You've got to go through a training. And then, yeah. Oh, I love it here. I'm maybe not too impressed how some things are run, but I love the Canadian Rockies. But if it gets into politics and stuff, yeah, I don't really like that guy. So I yeah, I don't look at that stuff. But yeah, I love where I'm at. There's a lot of beautiful places throughout. Everything from like the oceans to the mountains, the prairies. We've got a lot. So what do you guys think? What's going to happen here? What do you think she's going to get? I'm curious to know. Yeah, mom put on some pounds. I imagine if you're sitting in a cage, that happens. I don't know. Some people work out. I'll move this up a little bit. We want to hear them. They're unlocking her. What do you believe? What a situation to be because your kid's twisted. Just unreal. Yeah. Man S. Um, there's a few. I'd have to take a look back. Maybe we should do that. We'll see how this goes. I agree with you, Dandy. There's pretty strong opinions on both sides. And I'm literally, I have no clue. I'm just finding it really interesting because I mean, look what this kid did. And now the parents are paying for those repercussions. Like they're in deep doo-doo. So to me, it's just fascinating. I know I used to work with a kid, he was older than me and I was in my 20s, and he accidentally deleted his brother. What he didn't know a firearm was loaded and deleted his younger brother by mistake. And he's had a shite life ever since, you know. And that was before, I mean, you had to get licenses and register all your stuff. But I mean, his was a true accident. Hello, Grill. Yeah.
I have a question from the jury.
So this is the questions that they have.
Answer. The question is, can we infer anything from evidence for witnesses that the prosecution did not bring, specifically not bring in the shooter or other people who could answer how it specifically got the gun? The answer is no, right?
Correct, Judge.
Do I need to infer that? Do I need to send them 2.9 or 3.5?
I believe you need to send in 3.2, Your Honor, because a reasonable doubt is defined as a fair, honest doubt growing out of the evidence or lack of evidence, and it appears they're asking about lack of evidence.
No, they're asking if they can fill in the blanks about why the shooter is there, aren't they?
Yeah. Yes.
Yeah, we can't let them fill in the blanks.
I agree with that, but I think it goes.
I have my
they're
volume
asking
cranked,
essentially why the shooter
guys.
didn't testify or other witnesses, and the defense doesn't have a burden to put any on. So we believe it's important to remind the jury that the burden is on the people and that a reasonable doubt can come from lack of evidence.
Judge, again, you can't guess what they're thinking, you just answer the questions. Judge, I'm sorry, which instructions did you?
I was thinking, well, these are the preliminary instructions 2.9 and for 3.5, was it?
Oh, 2.9 I think would be appropriate here.
I'm sorry, 2.9, and what was the other?
3.5 maybe, but I don't think it says. I can bring them in and read 2.9 and 3.5 to them if you want. 3.5 talks about evidence, including any sworn testimony, witnesses, the exhibits, admitted evidence, anything else I tell you consider as evidence.
It seems on point, Judge.
I have no objection to 2.9. I am just making a record that I'm also requesting 3.2.
Okay, wait, do you want 2.9 or 3.5, either one of those? I'm trying to keep myself to answering the question that they asked. They have an instruction with them about reasonable doubt. They've heard it a bunch of times. They do not have in the jury room 2.9, although they do have 3.5. So,
Judge, the answer to the question is no, and I think reading 2.9 again and 3.5 probably appropriate given the question.
that's what I'm gonna do.
Thank you.
I'm gonna bring them in now, okay?
Thank you, Judge.
I'm sorry. what's that?
I'm gonna bring them in. see that. You want me to know, and I thought it'd be easier to bring you in than try to keep you in my term of handwriting. So, you asked, can we infer anything from evidence of witnesses that the prosecution did not bring? The answer is no. And you say specifically not bring in the shooter or other people who could answer how he specifically got the gun. So I'm going to take you back to our first day of trial and read you this instruction that I read you on the first day. When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. You also have a copy of 3.5, which I'm going to read to you. You don't have a copy of 2.9. That was read in the beginning of the trial. 3.5 says, when you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. So I'm hoping that I helped you. All right. So I'll have you return to the jury room.
All rise for the jury.
You may be seated. The lawyer's approach on the issue I brought up previously.
Yes, sir.
Okay, so I'll just boost that up a little bit so oh yeah, they've got it. They've got it off for now. So I thought maybe what we'll do while we're waiting is we'll take a look at closing arguments. I'll just get it set up that we don't have to go through some of the chit chat while we're waiting. We'll try and miss out on all their sidebars. So what do you guys think? What's going to happen here? Okay, I'm back. So this Friday,
Court, Jennifer Crumbley, case number 222799990,
Morning again.
Good morning.
I have reviewed, the extraction provided by the Oakland County Sheriff's Department and a sealed envelope to, the prosecutor. I reviewed all the text. I made a copy for Ms. Smith and, Ms. Smith, do you have an objection to anything in the text chain?
No, I don't. I would ask that if the text chain is used, that it just be admitted as well.
Yeah, okay, so I am going to maintain a copy of the text chain in my own personal file. All right, and I'm handing a copy over to the prosecution.
Okay.
All right. So,
Thank you, Jessica.
can we continue the trial? What do you think?
Absolutely. Give me just a minute to look at it.
Okay, yeah, it won't take you more than a minute, but yes.
John, you're gonna step out and hop, please.
Okay, so can I have Ms. Crumbley to take the stand?
You just need a few minutes, we haven't seen the.
It sounds like you're going to just give me a second. I give them us.
She's so loud in the courtroom, you can pretty much hear most of the stuff she says to her client. There we go. Okay, so they're just out there talking. So what we'll do is we'll bump this up until the state gets back. There we go. I found this part, this is where the state basically talks to Jennifer Crumbley, and it's interesting. She definitely stands her own, I guess. Like, that'd be terrifying. But I don't ever want to be on the stand for nothing, thank you. Yeah, they were not supposed to mention Ethan's name, just the bang banger. So, yeah, like they're saying, so the jury has no reason why Ethan wasn't there. They probably have no idea why the dad wasn't there. It's going to be interesting. It really is going to be interesting. Yeah. Pretty unreal, guys. How are we doing here? We're doing good.
All rise for the jury.
Crazy.
Good morning, we didn't see you.
Yeah, this is interesting in my mind.
I think that we all went out to breakfast this morning. We did not, as I described.
She is the only person
Sometimes things come up.
that the defense called.
If you need to take care of legal issues, I usually try to do that when you're not waiting for us, but that's not always possible. So I appreciate your patience. And we are going to continue on cross-examination. All right, did you raise your hand? You swear to affirm the testimony.
Hey, JJ, good to see you. Hello.
My name is Jennifer Crumbley, Jennifer, Crumbley.
Thank you. Mrs. Crumbley, I'd like to talk to
We're
you
looking
about
at
your
Friday
bidding
again,
system.
James.
But before I do, I want to make sure that you understand.
We're watching, waiting for Friday.
Okay, you
Or
understand.
sorry, waiting for Friday.
Stand
Yeah,
on the road.
it's Monday.
Tell the truth.
Waiting for
I
a
did.
verdict.
Understand that was the rules yesterday as well.
Correct.
All right, we're gonna come back to that. Now, you've been described by your attorney as a hyper vigilant parent,
Correct.
okay? Do you agree with that?
I do.
In fact, you called yourself a helicopter parent before.
Yes, I was.
So you told us you've spent a lot of family time together.
We did.
Now, I'd like to talk to you about what your digital footprint shows,
Okay.
what the evidence on your phone shows.
Okay.
Now, it's true, you agree with me that having horses is quite a time-consuming hobby,
It can be.
okay? It was for you,
It can be.
and that's what you said yesterday,
Yes.
okay? And you were at the barn for between 3 and 5 times a week,
More like 3 times a week.
3 times a week
Yeah.
for a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
Okay. And that's not including cash. That's just from Capital One and Flagstar Bank.
Correct.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have. Yes.
Now, except on rare occasion, you didn't bring your son with you to the barn.
He was not into horses. I would ask every time I went to the barn, but he didn't want to go.
So the answer was no.
No.
Okay. And at least as far as your horses being boarded with Kira Pennock from June of 2021 to November of 2021, your son never went with you. Is that correct?
I think he went once when my in-laws were in town and we met them at the barn.
Okay. But there was nothing stopping you from taking them.
No, he just didn't want to go.
Okay. It's a family atmosphere.
It can be.
Okay. Like the Halloween party that you had, that was for families.
Yeah, most of the kids there are young.
Okay. In the winters, you were on ski patrol as well.
Correct.
Okay. And that can be a bit of a time-consuming hobby.
It can be.
All right. And you would be on ski patrol between 1 and 2 times a week?
It's a total of 10 hours a week.
10 hours a week. Okay. So how many days?
I did doubles on Saturdays, so 1 day a week for me.
Okay. So you told this jury yesterday, you depicted your affair with Mr. Malash as a one time a week meetup at a Costco parking lot. Is that your testimony?
Correct.
Okay. But it wasn't just that, was it?
Nope.
In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips.
There were actual business trips that he met me on.
Okay. And included other individuals.
Yes.
What's Adult Friend Finder?
So where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app Adult Friend Finder on your phone.
I do not believe I had the app. on my
Okay. It
phone.
was found on your phone.
Okay, well, I guess it was on my phone.
Okay. And there were messages from you to other individuals.
Correct.
Your Honor, I would object that this is going outside of the scope of the affair with Brian, but.
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Walsh.
Well, I guess, with regard to Mr. Malash, I determined that, the defense opened the door. I don't know that I determined that the defense opened the door as to other.
She depicted herself as having one extramarital affair for about a 6-month period of time, where she met with him 1 time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
It's gonna get exciting.
All right,
It is what it is.
all right, well, go ahead, but
I won't delve too far
Okay, yeah,
into it, Judge.
really, this jury has been here a long time, and
I respect your time, Judge. I'll be brief.
You might have watched.
So, Mrs. Crumbley, I'm sorry, this is not a laughing matter. Mrs. Crumbley, on Adult Friend Finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay.
Okay, and you don't dispute August the 10th of 2021,
No,
August the 11th of 2021,
no,
and more importantly, November 21st, 2021.
no,
Okay, and more important than that, November the 28th, 2021.
no.
Okay, you don't dispute that evidence was found on your phone.
I don't dispute it.
Okay, and you don't dispute that it wasn't just you and Mr. Malash meeting after work hours. It was with you and Mr. Malash arranging with other individuals to meet after work as well.
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November the 28th. You remember that day?
Mm,
It was the day after you took your son to the shooting range.
I don't remember it.
You don't remember that day?
No,
2 days before the high school attack?
no, I don't remember what I did that day.
Okay. Well, you were pretty specific in what you did on November the 27th with the firearm. You remember that?
Correct?
All right. Now, November the 28th, 2021, you spent your time arranging a meetup with somebody, an adult friend finder.
I never met anybody with an adult friend finder that day.
Arranging a meetup.
Oh, okay.
I'm not just talking about the time that you spent physically with somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
And you'll agree with me, it's not just the time period at the Costco parking lot or the time period at the hotel or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devoted your own personal time and energy and focus to that, is it?
I guess I don't understand what you're asking.
Okay. Well, these meetups didn't just happen by themselves. You had to set them up.
Correct?
You weren't driven there. You weren't dropped off there. You set them up with somebody else.
Correct.
And that took your time and your energy and your focus to do so.
I don't believe it took too much time and energy, no.
Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves, that was in the spring of 2007, 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone.
No.
You don't dispute that at some point you read those messages.
No.
And you don't dispute that your son said at least one time, "Can you please text me back?"
Correct.
You don't dispute that when you're at the barn, your other messages show that you can take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a spot where I actually have service.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted, there are a number of pictures that James sent to you from the barn of a horse in a conversation about that particular horse. Do you
Okay.
dispute that?
No,
Okay. And in fact, dozens and dozens of pictures of the like.
I'm
You-
sure, yes.
You're sure, okay. And those pictures were sent to you with a timestamp on that Facebook message chat.
Okay.
Do you dispute that?
No,
No. Okay. And then you responded in that same time frame. Do you dispute that?
no,
No. So that conversation with that picture that was taken at the barn was occurring while one of you were at the barn.
I'm sure it was.
Okay. Now, you don't deny that your son wrote in his journal that he asked his parents for help. You don't deny that evidence that was admitted.
No, I don't.
Okay. And you don't deny that he wrote in his journal that he now had access to the 6-hour 9mm handgun.
I do not deny that.
And you don't deny that the 6-hour 9mm handgun was in fact the murder weapon.
I don't deny that.
And you also don't deny that that gun was gifted by you and your husband to your son on November 26th.
Describe gifted.
How about when you posted on Instagram his new Christmas gift?
Correct. And I explained yesterday that it was for him to use at the shooting range. We didn't just hand him a gun as a here you go, son. It was something he could use when we went to the range as a family together.
You don't deny that in April of 2021, you described your son as being depressed.
I didn't describe him as being depressed. I noticed that he was acting
You
depressed.
used the word depressed.
Yes, he was acting sad, acting depressed.
Okay. And you know what depressed means?
It means a lot of different things.
Well, to you, it meant depressed, and you wrote that.
Right.
You don't deny in April of 2021, the evidence shows that your son told his only friends that he had asked you for help.
No, I don't deny that.
Okay. And you also don't deny that he told his only friend that you laughed at him.
I did not deny that.
Now, yesterday you told us that you took those messages in the spring of 2021, which, by the way, is at the same time you started your affair with Mr. Malash?
Around that time.
Okay. So in the spring of 2021, when you sent those messages, or when you received those messages, you indicated it was messing around.
It was.
It was messing around. In your mind, messing around. That's what your testimony was.
Yes.
Okay. Even when he said, can you please text me back?
I didn't see his text message, so I didn't text him back.
Even when your phone logs show missed calls?
Can you ask it again?
Even when your phone logs show missed calls from your son in that time period?
No.
Now, you said yesterday about these messing around texts. You agree with me that there's no indication in any text message, either between you and your son, or any Facebook message between you and your husband, in any of those exhibits, in fact, anywhere on your phone, that indicated that any of those messages were a joke?
No, there weren't.
There weren't. And we're talking about hundreds of messages between you and your son, and thousands of messages between you and your husband.
Correct.
And you don't deny that you never once took him to see a therapist or counselor.
No, I did not.
You did not. Now, you testified, actually, Mr. Moss testified, that you would meet during work hours, and we've established that it wasn't just confined to work hours, but we're permitted to leave as you please.
Correct.
Okay. And your boss actually testified that no problem if you needed time off.
Correct.
If you have a family issue, no problem, you can go.
Correct.
If you were sick, no problem, stay home.
Correct.
Okay. In fact, you could work from home on an as-needed basis.
Correct.
In fact, on November the 30th, you didn't even ask your boss if you could leave. You just told him you were leaving.
Correct.
And you told him when you were coming back.
Correct.
And you told him when you were coming back after receiving a phone call from the school asking for an immediate meeting.
Correct.
Because that was at what, 10:05 a.m.?
Around that.
Okay. Now, had you ever been called? You have the CV on, please, Mrs. Williams. Had you ever been called?
I think it took some time for all three of them.
Sure, Judge. I have a few more questions I can ask before we get to these.
Okay, go ahead.
Have you ever been called to the school on an immediate basis before?
No,
Have you ever been told that your son had suicidal ideation before?
I was never told he had suicidal ideation before.
Okay, that's your testimony. But you've never been called to the school once for a meeting, I need to see you now,
No.
correct? Okay. So even before you have made it to the school, you had told your boss when you were coming back.
Correct.
So you had already put a limit on that meeting.
Not necessarily.
Well, you said, I'll be back in about an hour,
Okay.
right? That's your words.
About an hour.
Okay, those were your words.
Correct.
Doing the reruns from Friday. Her on the stand and
She
then
did a
next
74. You
we'll
see it?
watch
No, she doesn't.
Okay.
final argument.
Here, that's- Yeah, it takes a minute.
You see it?
Yeah.
Okay. This was sent to you, so Sean Hawkins called you at 9:24 in the morning, correct?
Correct.
Okay, you called him back at 9:27.
Correct.
You had a 5-minute phone call.
Correct.
And then in that phone call, he texted you the picture with it was drawn out, and he emailed you this original picture.
Yeah, he texted me the modified one and then later emailed me this one.
Later is at 9:32.
Yeah, like after I asked him for it.
You looked at it.
I did.
Okay. You told us yesterday you found it, I think your quote was a little concerning. What struck you about this?
Originally, when I saw the modified one, I was kind of angry at my son because we just talked about his missing assignments in geometry and his E the night before. Then when I got this one and opened it, it was concerning. I honestly thought the guy on there was a poor drawing of Batman, the way the thing in the cat. I thought it was a cape. I didn't know.
You thought that was a cape?
I did. I didn't look
Okay,
at
what
that
did you think of
closely.
the gun?
I thought it was a gun.
Yeah. What about the fact that it is identical to the gun that you got him for Christmas a couple days before?
I mean, honestly, it just it looks like a gun to me. I didn't even notice.
Well, you took a picture of the gun, you posted it on Instagram, you know what it looks like.
I do, but I didn't analyze it.
You saw Special Agent Brandon's testimony. He described how it's identical. And you told us yesterday how your son was a good drawer.
He's a very good drawer.
Okay. What about the thoughts won't stop, help me? Does that ring out to you?
Yes, that was what was concerning to me.
Blood everywhere, and there's a bullet. And actually, you were the one who bought the bullets on November the 27th.
Correct.
You later came to learn that those bullets were used in the shooting.
I did.
So you said yesterday it was a little concerning. Yet, you told your husband emergency in all caps.
Correct. That's why I left to go to the school and I
you said
texted
it,
him.
and he wrote back, "My God, WTF."
Correct.
And then you told him he was distraught about last night.
Correct.
Distraught's an intentional word you chose.
Correct.
Not sad. It's not a little anxious about school or his future. It's not talking about a video game. Distraught has a meaning.
Correct.
And you chose that word to send to him.
Correct.
So you went to that meeting, and this was November the 30th of 2021. And at that point, you'll agree with me that you knew prior to that day, the November 26th purchase date, that your son was wanting to get a 9mm. That's what you said yesterday.
Yes, I knew that they were talking about getting one because they had
Okay.
rented it in the past.
And you knew that he had shot one in the past.
Yeah.
Okay. And you knew that a 9mm was significantly more powerful than a 22.
I did not know that until I actually shot it.
Okay. Well, your dad took your son with James to the shooting range when they visited in July of 2021,
Correct.
and they talked about how powerful the 9mm was because they rented one.
Okay. I don't know.
Yes
if I
or
was,
no?
I don't know if I was part of that conversation, but if it was, it didn't register to me.
To register. Okay. You knew in the November 30, 2021 date that your son's friend had been taken without notice to your son.
Correct.
You said, I'm sorry, incorrect or
I said correct.
Correct. And you knew that when your son's friend was taken, your son was extremely upset.
He was upset. Yes.
He didn't go to school for a few days.
I don't remember that.
Okay. Well, if the school records show that he was absent for a few days after that, would you deny that?
I wouldn't.
And would you deny that he missed school because he was so upset?
I don't know if he missed school because he was so upset or maybe he was sick. I don't know.
Now, you told us yesterday and you acknowledged that that individual, that child, was like a second son to you.
Correct.
So he was the only one that your son hung out with.
Outside of school. Correct.
Okay. Well, who did he hang out with inside of school?
He named some names to me. I've never met them before, but he told me some group of kids that he sits eats lunch with and he talks to in class.
Did he ever visit their houses?
No.
Did they ever visit your house?
No.
The only other peer to visit your house was this student who left the state around Halloween 2021.
At that time. Correct.
We're talking about that time in October, in September, in at least August, July, June, May, all
Of
2021.
2021. Correct.
2021, thank you. Now, he left on Halloween, and you knew that your son was planning to hang out with him on Halloween,
Yes.
okay? But his friend didn't show.
I had texted his friend's mom the day before trying to confirm if he was still coming over. And that's when we found out that he was driven to Wisconsin and taken to that school.
Okay, so you're telling us you found out the day before Halloween?
Yeah.
Okay, so that didn't stop you and James from going to a Halloween party at the barn.
I don't believe it was on Halloween.
Oh, that's what Kira testified
It was
to.
it was the Friday before Halloween.
If there was a picture with a date stamp on it, would you deny it?
No.
Okay. And it didn't stop you from after you left that party without your son, you went to another Halloween party.
We did.
And your son was home alone at that point.
Yes.
So you talked to us a little bit about your son's hobbies in 2021. But in November of 2021, so we'll start distant. And I'll go one by one.
Okay.
So you told us about bowling.
Correct.
Bowling the team wasn't in session at that point in time, was it?
No, I think actually at that time he decided he didn't want to do bowling that year.
Okay, so he stopped bowling the
He did.
sophomore year.
He did.
And it wouldn't have been bowling season anyway.
I guess not. No.
So one hobby you talked about yesterday, that was not in existence in November 2021.
Correct. But we did still go to the bowling alley with him.
And you said that he worked, but would you be surprised to learn that he only worked a few shifts post-COVID?
No, not surprised at all.
So he wasn't at work every day.
No, he worked Tuesdays and Thursdays and sometimes Saturday mornings.
Okay. But not very often.
No, not very often.
A handful of shifts post-COVID, which of course, March 2020 is when things shut down.
He was working on a weekly basis.
And you knew that he didn't have any friends.
That's not the right way to put it. I knew he had friends, but no, he did not have many
You had
friends.
never met another peer his age who he referred to as a friend.
He actually had friends that used to come over prior to 2021 that he was still in contact
We
with.
went through defense exhibits yesterday from 2019 to 2020. I'm talking about 2021, at least from the time period where he sent you a message that he saw demons in the house.
Right. In 2021, the only friend that came to our house was the one that was
Right.
on the thing.
So you knew to be true in November of 2021 that he had no peer support.
I don't know what he had in school. He had told me he had friends in school that he talks to.
You never met him.
No,
And he didn't have any clubs at school he was a part of.
no, not that year.
So you told us yesterday that your son wanted to design video games.
Correct.
Okay. He wasn't in a robotics club or a coding club at the high school.
He did take a coding class prior to 2021, and he was in a robotics after school activity in middle school.
Talking about in
I'm
2021.
just telling you, he's been in that before.
Now, despite what you have called yourself as a vigilant parent and a helicopter mom, you never decided in at least November of 2021 to look at his phone.
No,
That's despite what happened in the spring of 2021, right?
what happened in the spring of 2021 did not concern me.
Okay. Now, the one thing that seemed consistent with your son, to you at least, is his desire to obtain a weapon. Is that right?
I wouldn't say that, no.
He had a consistent desire to obtain a weapon.
Not to me, he did not.
Okay. You didn't know about the 9mm?
Oh, I knew about it.
Okay. You didn't know about the 22s?
I knew about them.
And in fact, you posted on Instagram that he got himself a 22
Correct,
in June of 2021.
correct.
And from that time up until the November 26, 21 purchase, he was wanting to get a 9mm.
I know him and my husband had discussed getting a 9mm. I'm not part of those conversations.
But you knew about it.
I knew, but not that he was so, however you described it.
I said that he consistently had a desire to obtain a weapon.
I know they consistently talked about it, correct?
Okay. He didn't just talk about this is a gun, he talked about how he wanted the gun. You don't deny that.
Oh, no,
In November 26, you said you weren't there for the gun purchase.
no, it's not.
Okay. But are you telling us you didn't know it was going to happen?
I did not know they were going to the gun store that day, no.
Okay. But you knew that you were going to eventually get him a 9mm.
No, I did not know that.
Okay, so you're telling us that there was a surprise purchase to you?
It was surprised to me that they went to the gun store that day.
Okay.
It was not surprising to me that they purchased a gun that day.
And it didn't upset you that it bought a gun?
No, it did not.
It upset you that it cut into your Christmas tree shopping time, but it didn't upset you that it bought a gun?
Correct.
And you told us that it was, in your words, James's responsibility to take care of that gun.
Correct.
Now, you don't deny that, at least according to the cell phone evidence, the photographic and video evidence, you're the last adult to have possession of that
Correct.
gun. You were with him at the range on November the 27th.
Correct.
You saw your son shoot the weapon.
Correct.
You saw him shoot the last practice round before the shooting on November 30th.
At the range?
Yeah.
Yes, correct.
You saw how he stood.
Honestly, that didn't mean anything to me at that time until this whole case came about and I've learned what a shooter's stance is. So
He knew how to use the gun.
yes, he did.
Okay.
He's used one before.
In fact, he showed you how to use the gun.
Correct.
Okay. And the stance he took, you saw from the Oxford High School video, was the same. You saw that, right?
I don't know. I can't compare it. I don't know.
But you entrusted this responsibility. You agree with me that owning a firearm involves a great deal of responsibility and trust.
I do.
And you entrusted this responsibility to your husband, James.
I did.
If you look at Exhibit 423, that's the Facebook chat thread between you and your husband. It's pretty clear you didn't trust James with much. Would you agree or disagree?
Depends on what you're talking about.
Okay. Well, you didn't trust him to get out of bed on time.
Correct.
You didn't trust him to cut the grass when it was time to cut the grass.
He would cut the grass when it got to a length I didn't like. I didn't trust him.
You didn't trust him to update you on his whereabouts.
There's a reason behind that.
You didn't trust him to not turn off or turn on the Ring camera in your home.
Correct.
You didn't trust him to keep track of your son.
Oh, I trusted him to keep track of my son.
In those messages that we'll see in Exhibit 423, asking him, where is your son, over and over and over again, does that signify trust or distrust to you?
That was when my son was walking home from school. Not that I did not trust my husband with my son.
And you didn't really trust your husband to hold down a job.
It's not that I didn't trust him to hold on a job. He had a hard time holding down one after COVID.
Okay, and in those messages, you are constantly asking him about work, how much money he's making, and what he's doing to obtain employment.
Correct.
Okay. But this is the person you entrusted with a deadly weapon.
I did.
Why did you buy the Patriot defense rounds?
What are the, oh, those are that's the ammo. That was the ones my son told me to purchase. I didn't know anything about it. I'd asked him and he told me to purchase them.
So you told the jury yesterday, I think you repeated it again today, that the gift was for target shooting only.
Correct.
Okay. Yet you bought 100 rounds of ammunition
Correct.
and you only shot 50 while you were there.
Correct.
And those 50, at least according to some statements you made throughout the investigation, you put some.
The box of them, yes, I did. I hid them.
Now, on November the 27th, when you came home, you posted pictures of the gun and targets to your Instagram account.
Correct.
And then according to the location data, your location data, you left.
I think that's when we went, well, I don't know. I must have, yeah.
Well, you don't deny that.
I don't deny
Okay.
it.
And your husband, James, was gone all day, according to his location data.
I think so, yeah.
And you saw in the evidence that in the picture you posted, there's an ATF pamphlet on handgun safety for children.
Correct.
Did you read that?
I looked it over, correct.
Now, on Exhibit 74, here, I want to get back to this meeting for now. Exhibit 74, you don't deny that you could have left work for the day.
No, I don't deny that.
Okay. And you don't deny that you didn't tell the school officials, Mr. Hopkins and EJAC, about the gun purchase on the 26th.
No, we had stated that we went to the shooting range. I went to the shooting range with my son on Saturday.
You didn't tell them that you had gotten him that Christmas gift.
I didn't think it was relevant, no.
You acknowledge that you never told Mr. Hopkins and EJAC that it wasn't just a friend, but it was the only peer that you had ever met and left.
I probably said his best friend.
You acknowledge that you didn't go home to look for that firearm after the meeting at the school.
We wouldn't have a reason to.
So that the answer is that you acknowledge that?
No, I acknowledge that.
Okay. And you acknowledge that you had already made plans for the night to go to the barn.
Yes, I do.
Okay. And you acknowledge that you had the time to stop at your house before you went back to work.
I would have, but I didn't have a reason to.
Now, you had told us that you had never taken your son to any sort of mental health professional.
No,
Okay. But you know how to obtain that help.
correct.
In fact, you have prescriptions related to that.
I do.
So it's not that you didn't know who to call or how to call, you didn't.
Correct.
Correct, okay. Yesterday, you talked a little bit about how you express emotion.
Correct.
And in fact, the council asked you about your nerves when you testify. But you're capable of emotion,
Yes, I am.
right? Okay. And in fact, you had some explosive emotional fights with your husband.
What we did.
And that was in the home that you shared,
Correct.
okay? and with your son. We
Correct.
saw pictures of that home.
Correct.
And you told us that your son was at an age where he wouldn't text you back, "I love you."
It wasn't a text me back, I love you. It's like in passing, like, hey, Ethan, good night, I love you.
Well, yesterday you told us that your son was at the age where he wouldn't text you back, "I love you." Those
Well,
were your words
that,
yesterday.
yeah, but more or
Okay.
less like just saying it in passing. He wouldn't say it back. I say good night, Ethan, love you, and he'd be good night.
Okay.
For him to text me that he loved me was abnormal.
Abnormal.
Correct.
Okay. But you didn't respond to that text until 44 minutes later.
No, I was in a meeting at work.
Okay. And if you go through your entire text message thread between you two, the word love popped up how many times?
Between me and my son?
Yeah.
I have no idea.
3.
Okay.
The first is in reference to the game chess about a year before.
Okay.
And the other 2 times are right before your son committed this act and after the shooting when you responded. Does that surprise you?
No.
Robert, I would just ask if there could be a foundation for the dates of those texts, because I feel like we got just a few texts.
Okay, well, I think did you specify the date?
I did. Judge.
Two of the times were before and after the shooting, and the other time was when?
About a year prior. I could pull the date if council would like it.
And I'm also wondering if what the data he's relying on is coming from Jennifer's phone, where she deletes all her texts, or if it's coming from the shooter's phone. Because the prosecution's asking questions, I just want to know the foundation.
Oh, sure. Let me clear that one up. It's from your son's phone, so all the messages would be contained there. You don't deny that information would be accurate.
No, I don't deny it.
Now,
What time?
you told us that
Well, she said he asked if the chess one was a year earlier, and the other 2 were close in time to the shooting.
the day of the shooting.
Yeah, I know.
I'm asking,
Those have been admitted in evidence.
do we know,
What's that?
okay, but he's asking about the text overall, which have not been admitted into evidence, and I don't know that the text chain has all the texts. There is no foundation that what Mr. Keese is looking at.
Judge, in cross-examination,
texts.
if the
He's
witness-
asked if is that wrong? Would you argue with that? That's what he's asking. I mean, there are people.
I know, she just doesn't know what.
hold on,
okay.
counsel can't testify.
Okay. Well, there are people that end every conversation with love you.
Yeah, I'm with that.
Okay, so, and there are people who don't, right? So he is asking what's normal for them, and would she be surprised that how many times they'll hear?
Yeah, I'm just asking, I get that, and I get that it's not common. I'm just asking. what
Judge, this is
period-
argument.
I'm just
Counsel can
asking
argue
what
whatever she wants to.
period of text this is from.
You got regret.
Okay, well, she doesn't know what he's even basing these questions on. It's
How,
important.
okay,
Well,
it is inappropriate for counsel to
Okay, she
suggest
can
that
say I
or
don't know.
she or doesn't.
She can say I don't know, or she can also say I don't understand the question. You can
Okay.
say that too. If you, Mrs. Crumbley, if you don't understand the question, ask Mr. Pease to clarify it.
Okay.
All right?
All right, thank you, Judge. Now, yesterday, Mrs. Crumbley, you talked about going to the planning mode.
Yes.
Okay. And that was in reference to counsel asking you about emotions and how you express them.
Correct.
So I want to talk to you about your planning mode and your priorities from the time that you were arrested.
Okay.
Now, your phone calls were recorded from the time that you were arrested until now. You know
Correct.
that? You know that,
I
right?
knew that.
You know that, okay. And your priority on your first phone call, December the 4th of 2021, was on your animals and the cash recovered from the art studio. Do you deny that?
I don't deny it.
Do you deny that it wasn't until 10 days later and 14 calls later that you even mentioned your son? Do you deny it or not?
I don't, but I was under the impression that I couldn't mention him because I could get flagged at the jail.
Well, you mentioned him in later conversations,
I did.
okay? And in fact, in one, a year later, March 25th of 2023, you said he just needs to man up. Do you recall
I do
that?
not.
Okay, do you deny that you said it?
It sounds like something I would say.
In December of 2021, your concern was about a GoFundMe. Do you remember that?
No, I do not.
I'm gonna play this for you. Ms. Williams, can you have the volume up, please?
Is this submitted as an exhibit?
This is impeachment, Judge.
Very nice.
Well, there's no, Jennifer, that's. I should say, like, secret base, but I know there's a lot of people that call the lawyer about their my horses. So, I mean, I'm just, I'm throwing shit against the wall to see what's good. What's that? I'm just throwing shit against the wall to see what's good. I know.
Okay, that was between you and your dad,
Correct.
okay? And you asked him to set up a GoFundMe to pay for the board of your horses?
I did, yes.
You were concerned about other things related to yourself around that time, weren't you?
Yeah.
Is this still planning mode?
I believe so.
Okay. And you were arrested December the 4th. This is going to be December the 22nd.
Okay.
I got it from Yeah, okay. Can you have her Google how many calories are in a bologna sandwich with white bread? How many calories in a bologna sandwich with white bread? Yeah, American cheese. What was American cheese? Yeah. You get some mayonnaise on it? No, the mustard. No, there's not the mustard. And then peanut butter and jelly on white bread. And peanut butter and jelly on white bread. Okay, so you're looking at bologna right now. Is that what your lunch and dinner is? For the most part, yeah. And the other stuff, my cereal is now some of the actual. Well, there's some American cheese, yeah, American cheese. And an apple and a banana. Because they really just carb loading to me, and I want to make sure I stay at like 1,000 to 100 calories. No, I know bananas 100 calories. Is it okay? What about apple? Yeah. So the sandwich is 140 calories. Oh, 240. Okay, that's 300. So that is calories a day. And then peanut butter jelly and white bread.
Still planning mode?
Well, I wasn't planning there, no.
Okay. Now we're talking about how you describe planning mode. You describe that in context to statements you made to the police on November the 30th, 2021. Right? That's the context you use the words planning mode in relation to.
Correct.
Okay. So you told us that the last phone call on December 31st, that was still you in planning mode. I want to make sure we can have a depiction of what that is. And here's one from January 15th, 2022.
No, it's not an issue of that, it's an issue of, that bank seems to be all these, we had issues with their online stuff, and they had issues with, just all kinds of stuff. I don't know, how can that bank on these people, it's like, so. That child deposit thing? The what? Am I still getting a deposit of $300? That child thing the government does? I just got, because I lost access. For some reason, I don't know if I told you that. I had access. Well, I had access basically to view only. And it's hard to see everything on there. And then also I lost access. And then it took me, I lost access like a couple days before Christmas. Yeah. Okay.
Okay. Is that still planning mode?
We were talking about filing my taxes if you played the whole thing.
You were asking about your child tax credit here, so they get that $300.
My dad was doing my income taxes for me.
Now, when we started, we confirmed that you understood the oath that you just took.
Correct.
And the same oath you took yesterday.
Correct.
Okay. And you don't deny that you had $6,000 in cash in your purse the night you were arrested?
No.
You don't deny that your purse with the cash and 4 cell phones were in a plastic tote?
Correct.
You don't deny that that plastic tote was contained in a different plastic tote?
Correct.
You don't deny that your backpack with clothing items was found in a different plastic tote in a different area of that studio.
Correct.
Okay. And you don't deny that you knew you had been charged with involuntary manslaughter.
Correct.
In fact, as early as December the 1st, 2021 at 6:10 p.m., you were talking about how you're being charged with involuntary manslaughter.
That was what I was being told by a family that was texting me. That's what the charges might be announced as, correct?
Okay, and one is to Mr. Malash. There's a text to your cousin about you are being charged with involuntary manslaughter. You don't deny receiving that.
No, no,
That's Wednesday, December the 1st.
correct.
Right? And you sent your neighbor a message on Wednesday, the 1st of 2021, 6:55 p.m. that you were reading, they may charge us.
Correct.
Okay. And December the 2nd, 2021, you wrote, they're saying involuntary manslaughter.
Correct.
You don't deny that?
No.
And of course, you looked at different news articles about that the next day.
Yeah.
And later on that day. And then you texted after all of these messages and news articles on December the 2nd, 2021 at 2 p.m. We're fucked. You wrote that to Mr. Malash.
Correct.
Okay. And then you wrote announcing charges at noon on December the 3rd, 2021 at 8:17 a.m.
Correct.
And you wrote that to Mr. Malash, you wrote that to Kira, you wrote that to your dad, right?
Correct.
Okay, so you don't deny any of that.
No.
Okay. Now you told us yesterday that you popped 4 Xanax.
I did.
Okay, and your husband popped 4 Xanax?
Correct.
You said you went to bed about 11 o'clock.
It was around that time.
Okay. And the evidence that we have admitted show that you set your alarm for 6:30 a.m. and 6:45 a.m.
I don't know if it was me who said it, but it was set for that time.
Okay. And from the evidence, it shows when it was set too.
Correct.
Okay. And it was set a little after 11 p.m.
Okay, correct.
Yes? Okay. So yesterday you said, I want to say it was after 11 about going to bed. I want to say it was after 11, maybe around 11 o'clock when we finally went to bed. We both, I prescribed Xanax for anxiety, and we each took 4 because we knew we were going to turn ourselves in the next day, and we hadn't slept in 4 days, and we just wanted to sleep. The question was, okay, so you each took 4? Your answer, we did. And the next question was, okay, so the next thing, the next piece of evidence we saw that was coming in that art studio, do you recall that? Your answer, I recall my husband screaming, "There's people with guns against interface officers." Question, what were you doing prior to hearing your husband screaming? Answer, we were sleeping. Question, okay, were you aware that there was anything going on? Answer, I was not.
Correct.
That's your testimony.
Correct.
Okay. And you know when you say something that isn't true, it's called a lie.
Correct.
Okay. This is going to be exhibit 430. Council does have a copy.
Is it
The entire thread.
perfect? No
Here you
judgment.
go.
Oh, thank you.
Does the court have a copy?
Is this today's?
Yes, Judge.
Okay. Any objection?
No,
Okay.
Mrs. Crumbley, you knew the police were there.
430 is admitted.
Thank you, Judge.
Not until I woke up, no.
Not until you woke up.
Correct.
Okay. Now, we heard testimony yesterday, or throughout the trial, that 911 was called at 10:43 p.m. You recall that?
Yeah, I saw in the video, correct.
Okay, and on the video, the first officers arrived before 11 p.m.
Correct.
Okay, and either you or your husband, we couldn't tell from the video, but you tell me, was it you or your husband out there smoking?
That was my husband.
Okay, so your husband walks in shortly after the 911 caller walks in the building to call 911.
Correct.
That was on the video.
Correct.
Okay, and officers arrived. And then we've heard testimony from Mr. Kirtley, who had a studio there. We heard testimony from Sergeant Hendrick, who was in the fugitive apprehension team, as well as Corporal Shaw with the Detroit Police SWAT team about the amount of officers there.
Correct.
You recall that?
I do.
And you recall hearing the testimony that Corporal Shaw's team, their SWAT team, they actually used a 35-pound steel ram to bash in a door studio next to where you were at. You recall that testimony?
I do.
Okay. And your testimony was that you were asleep when the officers arrived.
Yes, I was.
Okay. But you had an alarm set for 6:30 in the morning on your phone, and that phone was found powered off, hidden in a tote, contained in a different tote, in a place away from the bed.
Correct.
You don't deny that?
No.
All right. And there are certain messages in 430. I'm going to go through them with you. This is actually to your attorneys. At the time, you had 2 attorneys. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. That's it. December the 3rd, 2021, 6:04 p.m. Do you recall that?
I don't, but I don't deny.
Okay, you don't deny.
No.
It. Okay. Your next message, the other phone broke. That's December the 3rd, 2021 at 6:04 p.m. The response was, when you can, we would like for you to call us. That was from either Ms. Smith or at the time co-counsel Marielle Lane.
Correct.
Your response, I'm sorry, this is from Marielle. Thank you. Shannon is calling you both shortly. Okay. At the top it says to and from. I'll make sure I identify for the record. From Shannon, Marielle and I are going to come get you guys in the morning. We do not think it will help to make a statement that you're coming back now or that it will be tomorrow a.m. We can say that we told everyone you were coming back, and as of tomorrow a.m., you were back. That's Friday, December 3rd, 2021, 7:02 p.m.
Correct.
Right? Okay. So that's after James had already moved the car around and backed into the parking spot.
I believe so.
From Shannon, we can show them that everything we said was going to happen did happen. That's Friday, December 3rd, 2021 at 7:02 p.m. Right?
Right.
Your response, okay, that's at 7:03 p.m. From Shannon, I'm going to drive home from my office right now and call you guys in about 40 to 45 minutes so I can get all the bond factor information written down from Marielle and me. That's Friday, December 3rd at 7:36 p.m.
Correct.
Okay. Your response, okay, we'll be waiting, 7:37 p.m. Shannon, I'm going to call in 1 minute. That's at 8:54 p.m. that Friday night. Your response was okay. Do you recall?
I don't, but I don't deny it.
But you don't dispute the records.
Correct.
The next message you send was, think we might have found, don't know, just heads up, please check. December the 3rd, 2021, 11:14 p.m.
That was written, but I do not believe it was written by me.
Okay, you don't remember, well, you told us you don't remember any of these text messages. You just
Right,
specifically
I
don't remember this
read
one?
through it, but,
You don't deny that this was on your phone, what we refer to as the burner or track phone.
correct, we
Don't deny that.
were both using that phone at the time because my husband's broke.
Okay. And then you wrote in quick succession, don't know, 11:16 p.m. We might have been found, 11:16 p.m. Laying low, 11:16 p.m. You don't deny that these are the records?
No, I don't.
Okay. Response from Shannon, oh shit. Friday, December 3rd, 2021, 11:16 p.m. Now we know from all of the objective evidence, the testimony, the video, everything that the officers testified to, they were on scene before 11 p.m. You don't deny that.
No, I don't.
You don't deny that there were hundreds of officers on scene.
I don't know how many were on scene.
Okay. How many did you see when you got pulled out of the art studio?
Honestly, I don't know. It all happened so fast. I knew there was more. There was a few. There was more than a few, but not.
You saw the body
hundreds.
camera footage.
Right.
I do want to make a point so everyone's aware. This exhibit was just made admissible this morning.
Correct.
Okay. So we actually just received it this morning, and when you testified yesterday, you didn't know this exhibit was coming to evidence.
Correct.
I want to talk to you now about the night before the shooting. November the 29th, 2021. You had testified that you got into a fight about grades with your son.
Correct.
Is that because you checked Power School?
Yes.
Okay. During that fight, did you lock your son out of the house?
We did not.
You don't deny that he was outside of the house?
He did walk out of the house. He was upset.
Okay. You told us that you took his phone.
We did.
That's not true, is it?
That is true.
On
We took
November the 29th, 2021, your son filmed a 19-minute video while he was outside describing what he was going to do the next day.
What time was that taken?
10 o'clock.
I don't know if he got it back. I know we took the shooting range away and we took his gun away. So I don't know if he got it back.
Now, all of the times that you were at the barn, there was nothing stopping you other than you told us you didn't want to go, right?
Correct.
There's nothing stopping you on November the 30th, 2021 from taking him home.
Correct.
Nothing stopping you. You know, actually, I want to go back to what you just said. You took his gun away.
We took the shooting range away.
You said you took his gun away.
No, I said we took the shooting range away.
Your son could have been with you those 3, 4, 5 times a week when you were at the bar.
He could have, yes.
Your son could have been with you on those times when you were with either Mr. Malash or somebody else.
No.
In the weeknights, he could have been with you after school, after work.
I wasn't with Mr. Malash at those times.
Okay, the other individuals then.
I wasn't with them either at those
Well,
times.
According to
I might have messaged people at those times, but I was not with anybody at those times.
he could have been with you on the Halloween party.
He did not want to go. It was a bunch of little kids.
And on November the 30th of 2021 at 12:51 p.m., you could have been with him,
I could have, yes.
and you didn't.
Nope.
Nothing further.
Thank you. Mrs. Crumbley, I just have two areas of questions for you. Mr. Keys played some recordings. Who were you on the phone with in those recordings?
And my dad.
Okay, so you asked a couple of questions about calories, and then what was the
I guess the child tax credit.
okay? How often did you speak with your dad?
During the summer, it was every day. They went back to work. It was just on the weekends. They're both teachers.
And how many hours a day do you spend with other people?
Sometimes it's none. Sometimes it's when they walk by my cell, I'll talk to them, but I'm locked down 23 hours a day. I get 1 hour out by myself. I talk to my clergy lady legally, so I see her. Sometimes I talk to the church priest, or I'll talk to my attorney. But it's about the most human contact I get.
So I guess one of my questions is, when you do talk to people, you talk about, are there more conversations than just those?
Right, there are.
And then that night on December 3rd, going into the 4th, after 11, there was one phone being used, is that right?
Correct.
Whose phone was being used?
It was my burner phone.
Who was using the phone?
My husband was using the phone.
Okay, were you also using it?
No, I was using my other phone. So he started using my burner phone. I use the one with our regular phone number to do anything on.
Okay, so these messages are from the burner phone
Correct.
to myself and Mario.
Correct.
So the ones after 11 o'clock, so at 11:17 or whenever these texts came in, what were you doing?
When I saw the video of my husband going to the car and having a cigarette, I knew I was probably sleeping at that time, because I did not like us not being together after what happened to us on the 30th when the police came to our house. So if he went out to have a cigarette, it was without me, it was most likely because I was asleep.
Okay, when guns were in your face and we saw that on the video, before that, had you been asleep?
Yes,
Are you absolutely sure about that?
I'm positive.
Okay, I have no further questions. Thank you.
I'm going to excuse you for about 10 minutes, and we'll see where we're headed. Okay?
All right, so Jerry.
Okay, so now we'll just move up. Closing statements. see where we are.
We previously corrected jury instructions and there was briefly a comment on.
Mhm. Okay. There we are.
Sorry, can you do my mic? Just look right here.
This go forward pretty far.
No movement in the court, nothing at all.
Just that way.
You want it still facing this way?
I want it like, almost in front of the witness box. Sorry. about that. Okay, thank you. Good afternoon. We told you in jury selection it was going to be 3 weeks, and it's now been 2 weeks, so we're a little bit ahead of schedule. This is our time for our closing argument, and I'm going to spend some time going through the evidence, and I'm going to spend some time going through the elements of the crime. I want you to know that I have been watching you diligently, taking notes and listening. So what I'm not going to do is spend a lot of time repeating everything that was said from the witness stand, because I know that you all listened. And I also want you to know that I really appreciate that. And I know the court does too. I told you during jury selection that it wasn't going to be easy. And it was not easy. Listening and watching and thinking about 4 young kids being gunned down in their school is not easy. You listen to every witness, you examine the evidence, and I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to convict people. I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth. And telling the truth sometimes means showing you things none of us want to see. Some of us don't agree with, some of us don't like. But I believe that that's my job. We don't pick or choose the very best things, because I believe that you should have the truth. And I believe that it's not my job, nor is it right to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts and you don't know what the truth is. My job here, our job, that I believe we have done, is to meet our burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter. The burden is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you had to sit and listen to a lot of very emotional things, a lot of emotional people who sometimes aren't emotional, but were emotional for this. Because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything. And I called witnesses to the stand to say things I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty. And I believe we've done that. The defense also has an important job to advocate and argue for their client. And they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when two sides disagree, to make a ruling, and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. The judge is going to give you instructions about the law, but I want you to go over what you now know, and I want you to think about it. And we're going to go over some of the evidence. But I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said. The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that. I want to start out by talking to you about the elements of the crime. Involuntary manslaughter, she is charged with. This case is based on two theories. You're going to have all this in their jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on two specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, the act that caused death, the defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. Two, she knew of the facts that gave rise to the duty. Three, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then four, the death of victims was directly caused by defendant's failure to perform this duty. Causation. The judge is going to instruct you, maybe more than once, and I'm going to say it, that there may be more than one cause of death. And it's not enough that the defendant's acts made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Muir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these four individuals was reasonably foreseeable. Now you look at that, all of that I have to prove. And it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts, some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard the result to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you have to find the following three things. One, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury and to a reasonable person, it would have been apparent that the result was likely to be serious. I told you I have two theories. We're prosecuting and charging based on two theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's two alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony. I'm not going to get into every single detail of each of these witnesses' testimony, because I know that you were listening and you were writing. You heard from Molly Darnell. Molly was a teacher in the school that day. She was in room 224. And she saw the firearm when it was raised, shoulder height, pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance. You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's an assistant principal at Oxford High School. I don't think there's one of us that would disagree that Christy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor. And then, when she finally came face to face with the person who had shot this student, she didn't move. She just stared at him. And he didn't shoot her. She testified that she knew him. She was his principal in middle school. And she just couldn't believe that he would do something like that, because she knew him when he was in middle school. You saw the video of that day and what happened. And he just kept going. And even after he left and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Tate Muir. We all know that she didn't and wasn't able to save Tate Muir. We heard from Cammie Batt, who sold the Caltech and the Derringer to James in June of 2021. She also sold the 9mm Sig Sauer to James with the shooter present on November 26th, the day after Thanksgiving. She testified that James came in and pointed right at the Sig and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next, we heard from Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning. And he raced and drove up there as fast as he possibly could, because it was very much his own community. You heard he went right in and he found Lieutenant Willis, and he said, "Do you know where the gun is, and do you know where it came from, and do you need help?" And so he was responsible for finding out where that gun came from, which he did. He was also responsible, because he chose to be, and watched the surveillance of the video and helped to prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that knows how, that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, because what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right. And that's how the investigation led to where Jennifer Crumbley's son learned how to handle a firearm that eventually resulted in killing 4 students in Oxford High School. Can you go back to that? Special Agent Brandon also testified that and showed the purchase, and we showed you each one of those guns. He testified that there is a distinction between a Derringer, a Caltech, and then the 9mm. And what we really heard from him was that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber, and it's a very dangerous weapon. He showed you what comes with every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence deaths. He talked to you about what a trigger lock is and the trigger lock statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was. Jennifer Crumbley told us whose gun that was. She told us when she posted on social media, it was his Christmas present, and she told you in this trial. That weapon is not just that weapon. It is the defendant's son's gun. It was gifted to him. And not only was it gifted to him, she bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates. We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video. And I want you to remember the look on his face when that target comes back in and he looks at it and he's smiling. Special Agent Brandon also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory, and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon. And he showed you the details, and we're going to talk about that later. And next we heard from Ed Rogoski. We now just call him Ed because he works for the Secret Service. And he testified for an entire day, and he had a lot of information, but he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing. That's just not seen very often. He sat right there And he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain. These are seasoned law enforcement. This isn't an act. They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me
Your
for
Honor,
that.
I would object.
It's
to
my
what-
opening. It's my closing. Your Honor.
What a witness tells her all the time, that's not evidence.
I'll move on. Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day. And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial. Okay. You'll be able to review the evidence. It was a lot. But he talked to you about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to, what she did, what she didn't do. And you can't hide from that. She tried. There's a lot of deleted messages, which are not coincidental. I don't think any of you believe that, but I'm going to tell you why they're not coincidental. He also talked to us about and showed you the messages between Jennifer Crumbley and her son. The messages between her son and his only friend. He introduced the voicemail that Jennifer Crumbley received the night before the shooting about looking up bullets. True. Pam Fine didn't tell her to call back. That's true. And she didn't call back because she didn't ask for a call back. We all know what she did do with that information. What she did do with that information is she texted her son, searching bullets. And we all know the phrases that we'll never forget. Did you show him your gun? This is the day before the shooting. Did you show him your gun? And the shooter responds, no, my God. LOL, I'm not mad. You just have to learn not to get caught. Kira Kennett testified that she knew Jennifer Crumbley. She testified about the amount of time that Jennifer Crumbley and James Crumbley spent at the barn. She testified about all the money they spent at the barn. Why is this important, ladies and gentlemen? It's not to show you that somebody's a bad person for liking horses. They're spending a lot of money on horses. It isn't. And it's not to say that somebody should spend every waking hour that they're not at work at home with their teenager. That's not the purpose of this evidence. The purpose of this evidence is to show you what Jennifer Crumbley cared about the most and what she was doing and where she was when her son learned to be a killer. Kira will tell you that she referred to her son as an oopsie baby and said he was weird. She rarely saw him. And that even after the one friend was taken away abruptly with no notice, they still went to the barn, even at night, and left him by himself. Which is absolutely normal to leave teenagers at home by themselves. Unless that teenager is showing signs of mental crisis and that teenager has lost the only person in the world that he has. And then she told us that when she got the worksheet texted to her that day by Jennifer Crumbley, she was very concerned. She was alarmed. And in fact, She said, bring him to the barn. And you also heard saw from the text messages that Jennifer Crumbley said he can't be alone. We know now that decision, that statement, she knew he couldn't be alone. She didn't decide to stay home with her son. That wasn't an option. She'd have to take him to the barn, where she herself testified he didn't want to go. You heard from two people who were at that meeting that day, Sean Hopkins and Nick Ejak. I'm going to tell you right now that this is not an argument as that the school did everything they should have done. I'm not going to say that to you. I'm not going to tell you that I like everything they testified to. I'm not going to tell you that I think it was okay they didn't look in the backpack. I don't think it was. But this is about Jennifer Crumbley's actions. And any attempt to make it about what these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring, it's about what she knew and what she didn't say. Sean Hopkins testified that he was concerned enough that he called Jennifer Crumbley. And her first response is, can you call his dad? Eventually, he emails her both copies of the worksheet, the original worksheet and the worksheet that was scribbled on. And she eventually comes to the school. But before she comes to the school, she texts her husband, emergency. Emergency. Along with, I'm very concerned. And James texts back, WTF. They're concerned. For the first time she testified ever, they're called to the school in the middle of the day, and they have that worksheet. Sean Hopkins is going to tell you that calling parents in the middle of the day and asking them to get a kid help is a pretty drastic action. And that he did in fact do that. And he gave them the list of places to call. He testified that when they entered the room, Jennifer Crumbley didn't greet her son. Jennifer Crumbley didn't hug her son. Jennifer Crumbley didn't engage with her son at all in the entire 11 minutes she was there. And we know she wasn't going to be in that school very long. She'd already told her boss she'll be back by 12 or 12:30. Doesn't leave a lot of time for the meeting at the school. It's a 20-minute drive. Sean Hopkins will tell you that what he felt mostly in that room for the shooter was compassion. He didn't want him to be alone, and he felt really bad. And he also knew mom and dad decided, no, we can't take it. We have to go to work. They said that in front of their kid. He knows very well what they do. He knows his dad works for DoorDash. He knows his mom and her ability to work flexible hours. She worked at home. But they left. She did not hug him goodbye. She did not touch or even acknowledge him. And we know now from her testimony, we know why. She was mad. She was mad at him. She did not think that he should have done that, and she thought this was a discipline thing, and she was very angry. We heard from Nick Ejak. He's the dean of students. He also testified and corroborated what Sean Hopkins told you, which is that the meeting was called. They were concerned about a mental health issue. They told mom and dad he needs services. Here's a list of the services, and they defended Jennifer Crumbley seemed irritated by it. In fact, when she walks into the room, she doesn't sit next to her son. She goes back here and stands. And that meeting ended with her saying, "Are we done here?" They're consistent about that. Nick Ejek testified he didn't think there was any risk. I don't like what he said, and I knew he was gonna say it. But it's not my job to put witnesses up here and only say things that I want them to say that helps my case. It's my job to present evidence that's the truth, because you have to know the truth. Sergeant Joseph Bryan is the first law enforcement that had contact with Jennifer Crumbley and her husband right after the shooting. And you saw the interview in the substation. And you saw the demeanor of the defendant. I want you to remember something. It wasn't even an hour. It was around an hour after the shooting took place. She's on her cell phone. She's looking to see if it's on the news, she said. We also know that there were deleted messages. We don't know when she deleted them, but we know there were messages deleted after the time of the shooting, from the time that the phones were seized later that night. He asked about the gun, and you heard what she said, what they both said. It was hidden. It was hidden. She read the text message. Oh, he said he loved me. And she reads the text message. And then she said, I texted him, I love you back. It was 49 minutes later that she texted, I love you back. And it was after she already knew that he was the shooter. She doesn't say what the text after that is. She leaves that out. The text after that is, Ethan, don't do it. She doesn't say, well, we were at the school, but he was also caught searching bullets that night, the night before. She doesn't say that, and I told him, don't worry about it, just don't get caught. She doesn't say that they had just purchased the weapon and it's not secure. What do they say? The very first time they are asked about what Jennifer Crumbley's asked, where was this gun? The very first time, what did she say? It was hidden. She does not say there was any locking mechanism at all, and neither does James. It was hidden. You're at the police station. Your son's in the next room. You know the murder weapon was the weapon you just purchased for him. And when you're asked where it was, you say it was hidden. We also heard from Andy Smith, who was Jennifer's boss. He testified she could have absolutely gone home. She works from home, and there's flexibility, that they have kids that come to work, that the meeting that she wanted to get to was not in any way mandatory. And he testified about some very bizarre communications. He testified that as soon as she left, he got a text saying, my son, the bullets are gone, the gun is gone. He must be the shooter. Oh my God. Those were deleted by Jennifer Crumbley. We don't know why. I think there's a lot of circumstantial evidence to suggest why, which is those are statements you don't want on your phone. And then, not 3 hours after her son shot and killed 4 people, and he's already in custody, and it's already clear that he is probably never, ever, ever going to be out of prison for the rest of his life. She's texting, don't judge me based on what he did. I need my job. Her explanation for that, she was in planning mode. The next witness is Amanda Holland, who testified that she came back to the work that day. She had the worksheet. Anthony Smith also said she before the shooting occurred, she was down, she was sad. I feel like a failure as a parent. This is before the shooting. And she also tells Amanda about this, and she tells Amanda he can't be alone. So I'm just going to take him to the barn tonight. We can get to it a little bit later. I guess what's really hard to comprehend is how before the shooting, just based on the meeting and what she knows and the drawing, she thinks she's a failure of a parent. But she sat right here and said, After all, she doesn't really think she was a failure as a parent, and that's after she knows everything that happened. Detective Adam Stoyak executed the search warrant at the defendant's home. I want to make it really clear. Jennifer Crumbley is not being charged with involuntary manslaughter because she has a dirty house. That's absurd. And you can see pictures so we can prove that she didn't have her house cleaned. I don't care if her house is clean or not, and I don't think you do either. Those pictures are shown to you because that is where the shooter lived and it's where she lived. And you saw his 2 bedrooms. There was barely a place for him to sleep. The testimony shows he had no person in his life after that friend left. He was not in a club. He was not in sports. He wasn't working. When I see those photos, what I think is, yeah, 2 rooms that were completely filthy, dusty, covered with clothes everywhere. But then I think, what? That is where he spent 99% of his time. It's where he ate Thanksgiving dinner, just days before the shooting. The search warrant photos were also shown to you so you could understand where these guns were stored. We have a pretty good idea that the Kel-Tec and the Derringer were in what's called the gun safe. The lock was 000, but we know that they were kept there. What do we know about the SIG, the Jennifer Crumbley's son's gun? We know that there was a box on the bed and the ammunition next to it. This is the box. This is the box. I'm sorry, this is the he's going to show you in a minute. This is the box of the Kel-Tec, which was found with this cable lock inside of it. Where she kept the other guns? No.
I'm sorry, is that the box or the key? Is that the box or the safe?
This is the box. What's the box? It was in the kitchen, in a cupboard, down in the
But
cupboard.
the empty box was in the kitchen, right?
I don't, what is it?
Your Honor, this is my closing argument, and I would just like to finish, please.
Sure, can you tell us what the number is?
Yes, it is 35.
Go ahead.
This was found in the kitchen. Inside is the cable lock. This was found on the end of the defendant's bed. Special Agent Brandon showed you what it's like to open this up and close it. You do that, Pat? It's not an easy thing. So what this is laid out on the defendant's bed, and the bullets are right next, the box of the ammunition is right next to it, empty. The story, one of these stories that is told by Jennifer Crumbley is he must have come in there when they were sleeping, because she was in that bed all night long, and they left after her. Except that the ammunition was in the box. Taking it out and leaving the box while your parents are sleeping doesn't make a lot of sense. And it doesn't make a lot of sense that this was taken, the weapon was taken out of this case with no one hearing while they were sleeping. And you are allowed to use your own common sense. He also testified about the search warrant. He testified where this cable lock was found, and he testified where the case and the box was found. And he testified where the gun safe was found. It was not, unlike what Jennifer Crumbley alleged, stored separately from the ammunition. It was actually right next to the ammunition. In a gun safe, the other 2 guns with a combination 000. Sergeant Peschke arrives at the scene, doesn't know anything about the Crumbleys, doesn't know that they've already been to the substation, doesn't know that they were at the school that day. He's there and was ordered to be there to keep the house safe while they are waiting for the search warrant. And in doing so, he needs to keep the defendant out of the house. She goes in the back of the car, and you saw the video. She now tells Sergeant Pesky, she actually never really looked closely at that worksheet. Now that she looks at it, it might be disturbing. We know that's not the truth. The question is, why is she lying? She says that the 45 caliber gun used at the school, and he asked if it was, and tells him no, it was a 9mm. The other is a 22, I think. She said that they had a fight the night before with her son over grades. And she says, so we told him, no gun range, no phone. Those are his trigger points. Ladies and gentlemen, that phone was never taken away from her son. We know that. We know that because he had it the night before and he had it at the school. We know that because when Jennifer Crumbley was asked about it and asked, when did you take this phone away? We know that he made that video in that shed about the school shooting with his phone at 10 o'clock. The phone was never taken away. Why is she saying that? I don't know. Then she says, my biggest fear was that he turned the gun on himself. And when he asked her, do you ever keep guns in your car? Here's what she did. Shook her head. It's not what she says here today. Next, we heard from Bob Patelis, who processed the scene. And you saw those pictures, and they were hard to see. He told you that there were 32 fired cartridge casings. He collected all that evidence, took all the photographs, and recovered the murder weapon. Lieutenant Marsvan was also at the school that day, and he testified that he picked up the phone and saw the screen and saw that the last text was, Ethan, don't do it, from Mom. He executes search warrants for all of the devices and the home and sends a team, including Officer Pesky, to secure the house before the search warrant is executed, which is what they do. He testified that when he went into the house, he finally got there and he needed their phones. And he testified that Jennifer Crumbley said, no, I don't want to give you my phone. I'm not giving you my phone. She finally relents because her husband says they're going to get it either way. And then she doesn't want to give the passcode up. She doesn't want to give the phone up. But the most important thing that Lieutenant Marsman said is when he described how he had to identify the body of Hannah in Madison that day. Dave Hendrick is retired, but he's the former sergeant in charge of the fugitive apprehension team we call FAT. And his job, his only job, when he was doing that, is to find people who have felony warrants and haven't turned up. He has a lot of ways to figure that out, but he was asked to find Jennifer and James Crumbley to make sure they turn themselves in. But one of the other primary goals he has is that they turn themselves in safely. And she was given every opportunity to do that, and she did not. I want to talk to you about something. The judge is going to instruct you that you can consider flight. It's not an element to the crime. I don't have to prove that they fled. The reason we introduce this evidence is she's going to instruct you that you can use that as a sign of consciousness of guilt. What do you do if you know you've done something wrong? You can use that to show consciousness of guilt. And we're going to get to it, but I believe we have shown that beyond a reasonable doubt. He's going to tell you that the defendant with her husband immediately began to avoid detection because they're pulling cash out. They're pulling cash out of their son's bank account. They're pulling cash out of their bank account. Where's their son during this time? He's at Children's Village being arraigned with his court-appointed lawyer where they had the opportunity to go see him, where the opportunity to go to that arraignment, and they did not. Because they never even went, they fled their house and went to a hotel, and then they ended up at an extended stay, and that is where they ultimately left one of the Kias, backed into a parking space. He's going to tell you that he eventually did apprehend the defendant. You've heard a lot about that. And he's going to tell you that there were hundreds of law enforcement officials on the scene when she was apprehended. Luke Kirtley, I know you will not forget him, coincidentally knew a lot about cars, and coincidentally pulled into that parking lot right about the time, and coincidentally had just seen the wanted poster, he called it, with a description of the cars and a photo of the defendant. And coincidentally thought, maybe that's the car. And he watched the video where he goes around and he sees the license plate and he plays it cool and slowly walks into the building and then makes the call to 911. He describes to you how within minutes, police officers arrived, and then swarms of law enforcement arrived, SWAT, the marshals, ATF, the sheriff's department, Detroit PD, all sorts of law enforcement show up immediately. He also testified that the unit where Jennifer Crumbley was actually found was very close to his, and it faced the parking lot, and the whole wall was windows, and it was on the first floor. And he's going to tell you that the whole parking lot was lit up with law enforcement, lights, sirens, all kinds of things. Next, we heard from Captain Corporal David Shaw, and he testified that once he got there, they took a 35-pound ram to breach the door, which was right outside the unit where the defendant was found. We heard from Brian Deloche. Also, didn't love a lot of things he has to say, but you deserve to know the truth. And the truth is, like it or not, this is who Jennifer Crumbley spent her time with. And she told him that morning, the gun's in my car, and I'm afraid my son's going to do something stupid. Before the shooting, the same day. You've also learned that although their Facebook thread in general was always deleted, post after the shooting, it remained, except she deleted, not unsent. Rely on your own memory about what that testimony was. Those were not unsent messages, they were deleted, and you heard Ed Growski tell you that. But these were the two that were deleted. On the run again, and we're fucked. William Freer testified what was found in the building and the art studio where Jennifer Crumbley was found. You saw the photographs. You learned that there was a little over $6,000 in cash. You learned where the phones were found, and a cash, and a purse, in a plastic tub, in another plastic tub with a lid on it, feet away from where the mattress was, and there are other things where you learned all those phones were off. He also testified what else was found. Booze, orange juice, ice, and avocado, bananas, socks, blankets. And that is the room where Jennifer Crumbley was ultimately apprehended. You heard from Lieutenant Lewis, who was the officer in charge. He told you what it was like in the school that day. He described the autopsy protocols that were done and how each of those kids died and where they were shot. He told you that both Justin Schilling and Madison Baldwin were shot in a contact wound, which means the gun was either very close or actually touching their head. he showed you the video of the shooting. And again, this is not to incite emotion. The video of the shooting shows Jennifer Crumbley's son taking a stance he clearly knew how to take and was trained to take. And you watched his demeanor and the calculated, cold way he proceeded through those hallways looking for people to shoot. You saw the surveillance of how he ultimately surrendered. Walked out after executing Justin Schoen, laid the gun on a waste paper basket, made it safe, took the magazine out, and surrendered. We showed you and introduced the bank records that show you what they were doing after charges were either very soon coming and after they were announced. And he showed you an in-car video of Jennifer Crumbley and her husband, who just a few hours after the shooting embraced, kissed, whatever happens, I love you. Don't say anything to the police. One of the elements we have to prove is what a person using ordinary care would have known about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge about her son matters, but it's two different stories. It's what she knew before the shooting, and it's what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda Holland he's lonely. He's hearing things around the house sometimes. She says, I'm a failure as a parent. The message to her son's friend's mother, he's kind of depressed in April. She texts that. And then the messages from her son. The messages in March about he's seeing things. Things are flying off the table. Now she wants to tell you that was just a joke, but I think you really need to consider whether a 15-year-old boy is going to text, could you at least answer me or reply to my text as a joke? And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why. He was just messing around. But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in the in-car, I never even thought like he would have any mental issues. Like he never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid-back kids. In the substation, he's never done anything. He's never done anything bad. After the shooting to Brian Lowe, she's never done anything wrong. Jennifer Crumbley has said a lot of things about that drawing and that meeting at the school. She sent the drawing to James, and Kira and Andrew, as I said before, with the call now, emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling. And she tells Amanda that the drawing was really scary. She agrees. After, this is what she says in the substation. Nobody didn't seem worried about it. And he said that my son's more than welcome to stay at the school, or he could go home. And I really wish we had taken him home. In the in-car, she said, I didn't even look at that closely. Now that I do, when I was at the substation, I looked at it closely, which we know is not true. I looked at them closely, and they're a little disturbing. Well, they're very disturbing because look what he just fucking did. And then to Malo, she says, the school was very nonchalant, but the paper they showed me had all of the things scratched out. That's just not true. It's just not true. And you don't have to believe me because we have evidence it's not true, and you heard it. The statements about the gun are also numerous. She said, we've heard her testify the gun was in her car. We know that she's acknowledged that she drove to the gun range. There was no lock on the gun when she drove there. She returned with the gun. There was no lock on it, but she said James locked the gun when he got home. She didn't see him do it. She testifies at trial. James is responsible for the gun. In the substation, though, when asked where the gun was, hidden. In the in-car interview, James flew home and he's like, I had the gun hidden and I told him where I hid the bullets. He asked whether she kept the gun in her car. She shakes her head no. And she tells Veloce, after the next day, we had the screen lock on it. It came with in the case. Everything was secured, not loaded, the bullets stored separately. Oh my God, oh my God, oh my God. That is not what she says in the substation. Jennifer Crumbley begins distancing herself from her own responsibility about the gun. You heard her testify that they wanted to get the gun. It was my son and my husband. My son did a lot of research on the gun. I guess when I was shopping. She doesn't say she didn't know. She doesn't say that she didn't approve. She says it really interfered with going to get Christmas trees. That was what she was upset about. And she said, it's James's responsibility. However, as I've shown over and over, at the substation and in the car, it's we. It's we take him to the range. It's our hobby. We go to the gun range. That's what we do. We just got him this gun. Sitting here today, it's all James' fault. It's not his. And then, of course, the statement that we don't really have to question whose weapon it was. Jennifer Crumbley posts, Ethan and James Crumbley both got handguns this week, testing them out at the range. That's in June. The evidence really shows that the shooter owned 2 guns. But for sure, she acknowledges Mom and Sunday testing out his new Christmas present. You heard evidence that was presented to you about the journal that was found in the bathroom by the shooter's backpack, right the bathroom that he exited and started shooting. I have zero help for my mental problems, and it's causing me to shoot up the fucking school. Next slide. First off, I got my gun. It's an SP 2022 Sigbar 9mm. The shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this. So yeah, I'm going to prison for the rest of my life, and many people have about 1 day to live. One of the things I want you to ask yourself when you go back in that room is why, after hearing that there's an active shooter situation and knowing that your son is involved, you are taking the time to delete text messages and look at the messages that were deleted. We're on the run again. Helicopters, not sure where to. I'll message you, and we're fucked. Deletes, the gun is gone and so are the bullets. Oh my God, Andy, he's going to kill himself. He must be the shooter. Ethan did it. Those were deleted from her phone. She deletes all of the things she says about the drawing to Kira, including making sure that she still was going to get her lesson that night. This is the timeline from when in March, which you've heard a lot of testimony starting in about March, was where we first have evidence that he was struggling. He was hallucinating. He was seeing things, and he wanted her to text back, and she didn't. We know that he had some incident, and he said it's a mental breakdown in April. You saw text messages between James and Jennifer saying, did he say anything about last night? He woke up in our bed, he didn't know where he was. we don't know what that was about, but we certainly know that that is not evidence of somebody who is completely fine and stable. In fact, lots of messages from Jennifer Crumbley saying, I'm worried he's gonna do something stupid. In April, she texts her friend that she thinks he's depressed. The Caltech and the Derringer was purchased in June. They go to the shooting range in June. They go to the shooting range in August. They go to the shooting range in September. And then in November, they buy the Sig Sauer. And we see the shooting range that Jennifer Crumbley went to with her son, testing out his new Christmas present. Here's what we learned Jennifer Crumbley did after the shooting. As soon as they took her phone, they bought burner phones in the pier at 8 o'clock the night of the shooting. They checked into a Holiday Inn Express that night in the pier. They then left and went to an extended stay in Auburn Hills, which Lieutenant Willis testified was almost across the street from a police department. Upon learning that charges were possibly coming, and the same day charges were announced, they leave that hotel and drive to Detroit. They withdrew $2,000 from a Flagstar Bank on December 2nd. They drive to Owasso, an hour away, she says, because we just didn't want anyone to recognize us, to buy replacement phones. She texts that she's on the run again. Helicopters are not sure where, I'll message you to, at 7:31 a.m. on December 2nd. She texts on December 2nd, we're fucked at 2 o'clock. On December 3rd at 4:59 a.m., she texts, I'd rather die than go to jail. Then she withdraws $4,000 from another Flagstar on December 3rd. She checks out of the extended stay on the 3rd and drives down and arrives at Bellevue at 10:58 on December 3rd. You heard what happened. You heard her testimony. The facts do not support the story that Jennifer Crumbley told you. They just don't. There is no possible way, and Luke told you that, and so did Corporal Shaw, that you could be in that building with that many law enforcement and not know that somebody was there. And we don't even have to use that today's testimony, ladies and gentlemen, because she texted herself, I think we're caught, we're laying low. She texts that, we find out, and this is evidence we got this morning. She texts that after she's already said she took 4 Xanax and went to sleep. Now you saw that video. You saw that video. All those people for over 2 hours, they're sleeping, and even when they come into the room, they still don't even act like they get up. It's just not true. And we know it's not true because they'd already taken steps. She had hidden the phones, powered them down, separate from all the other things they had, with the cash. Jennifer Crumbley wants you to believe that if only the school had done something different, we wouldn't be here. If only the school. Well, let's talk about what she knew that no school employee knew. She knew about the text messages in March that he was about a demon, throwing bowls, clothes flying off the shelf. She knew about the March 18th incident of waking up in his parents' bedroom and like he had way too much to drink and asking why he was in their room. She knew he had previously asked for help and to go to the doctor, and she laughed at him. She knew there were multiple guns in the home. She knew her son had been gifted a gun just a few days before the shooting. She had posted it on Instagram. But apparently, it's absolutely fine for all your Instagram friends to know that you got him a Christmas present with a 9mm handgun, but it's not okay or relevant to the people sitting in that room with that drum. She knew that that gun looked identical to the one in the drawing. She knew that the gun was accessible to him. She knew it wasn't stored properly. She knew that he was proficient with the gun. She knew he had access to ammunition. And she knew that her son was upset the night before. Now, that says he was locked out. She told Amanda Holland he got locked out. She doesn't acknowledge that. She does acknowledge that he did leave the house that night because he was upset. And we all know what he did. We all know what he did. He went to that shed and recorded that video.
I object, that video did not come into evidence.
Okay, it is in the evidence. It's
Okay.
not. You're right.
That's true. Let's go back to the elements. Ordinary care. What ordinary care, the smallest, tragically smallest thing she could have done to prevent this? She could have stopped at home on the way back from the meeting. She goes right by her home to see where the gun was. She could have stopped on the way back to work. She could have searched the backpack. She could have asked her son where the gun was. She could have locked the ammunition. She could have locked the gun. She could have taken him home. She could have taken him to work. He could have gone with dad. He was door dashing. She could have told the school that they just gifted him a gun. She could have embraced her son. She could have said, can we talk to him for a minute alone? She could have looked at him and said, I care about you, I love you. She could have at least acknowledged he was in the room. She could have told the school about her son being in crisis previously and asking for help. Ordinary care would have included all of those things. And the tragic part about it is none of it was hard. None of it. The smallest thing, just the smallest thing, could have saved Hannah and Tate and Justin and Madison. The smallest of things. I have to prove that there's reasonable foreseeability. And that worksheet right there that Jennifer Crumbley saw just hours before the shooting is reasonable foreseeability. And we're going to show you in the next slide. That's the picture of the gun. It's not just any gun, ladies and gentlemen. It's the gun that they just gave him. Blood everywhere. That's what he wrote with ammunition. I didn't show you the picture with the blood because I don't think you need to see it again. But we know what happened in that school and in that hallway. Here's a picture with 2 bullet holes and blood coming out of the figure's head. And look at that. That is where those shots went. Those are from the shooter's gun. The thoughts won't stop. Help me. These are all of the things that were texted to Jennifer Crumbley. This was in March, but he's writing it on a piece of paper and he's showing it to her. That is foreseeability. He's telling in that drawing, this is the gun that was purchased for me. Help me. Blood everywhere. The world is dead. I know you won't ever forget the video, but if you look at the defendant's son and see that there was no emotion, none. He was only concerned in a very calm manner for finding as many people as he could to kill, and he did. My life is useless. These statements from the defendant's son are just heartbreaking. I actually asked my dad to take me to the doctor yesterday, but he said, just give me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I am having bad insomnia right now. I need help. I was thinking I could call 911 so I could go to the hospital, but then my parents would be really pissed. Like, I'm mentally and physically dying. Let's talk about the cable app. Jennifer Crumbley says that the cable, the weapon was used, but it was locked in a cable app. It came with the case. This cable app that came is the cable app that came in that case with the SIG. It's never been opened and it's never been used. This is the last picture that we have of that gun until we see it murder 4 kids on November 30th. And the person holding it is Jennifer Crumbley. She's the last person that we see with that gun. She's the person that said it was in her car, then she said it was in her house, it was her husband's responsibility, it wasn't hers. That's what she told you. She knew he was distraught the night before. He texted her, "I love you." She told you that's never happened before. She did think it was abnormal or odd. She knew he was looking up bullets in the school. She knew he was watching violent videos. She knew he was proficient with guns. She knew he was previously in crisis. She knew his only friend that he talked to was just gone. She knew all those things. And then her own statements, ladies and gentlemen, when she took the stand. She testified that when she's looking back, she still wouldn't do one thing different. Not one. Not any of those tragically small things. Even now, she told you she wouldn't do anything different. And then she also told you that we took his gun away. You heard her say it. And then she said she doesn't think of herself a victim, but she has lost everything. You're going to hear the instructions from the judge, and you're going to take the facts and the witnesses and the evidence and use what you promised to use, which is impartial, honest assessment, and find what you believe the facts are in this case. The flight, evidence of the flight and what they did after is not an element I have to prove. But what does it show? It shows the minute this shooting became public and ended up in the paper and the media, Jennifer Crumbley started telling a story and then she ran. And she didn't run just because she was selfish, ladies and gentlemen. She ran and she started deleting text messages and she started telling a different story because she knew she had done something wrong. That's the only reason you start deleting text messages. It's the only reason that you start saying something that isn't true. It just isn't true. Jennifer Crumbley drove to Detroit with a bunch of cash and 6 cell phones powered off. You can consider that as consciousness of guilt. Everything she did from the time she found out that there was an active shooter and had a 10-minute call with her husband. They both say they went right. He called 911 right away. He did not. He talked to his wife for 10 minutes, over 10 minutes on the phone before he called 911. But the facts changed because it was an immediate attempt to misrepresent what actually happened. Why is a mother whose son just killed 4 people thinking about deleting her text messages? Why is she saying things that are not true about her son? Why does she care about her job? Why does she care about her first lesson? Why does she care about any of these things? Because she knew she did something wrong. And she's deleting all of those things because she wants you to believe that she's somebody she's not. And you know what she's not? She is not somebody that used ordinary care to prevent what was foreseeable, reasonably foreseeable, that could have happened. Injury or death, and it did. It did. Those words on that paper helped me. She walked out of that school within 11 minutes, didn't so much even address her son. She did not give him the help that he wanted. And you can argue about the months before and the weeks before, but if you just even look at what happened that day, she walked out of that school and she knew something bad might happen. What does she do when she gets back to work? She all of a sudden texts her son, "Are you okay? You know you can talk to us." These are the actions of somebody who was worried. She was worried and she was concerned and she was panicked until after. And then it's a different story. Why? Because she knew she had done something wrong. She walked out of that school when just the smallest of things could have saved, could have helped Hannah and Tate and Madison and Justin. Just the smallest of things. And not only did she not do it, she doesn't even regret it. We have proven beyond a reasonable doubt that she is guilty of 4 counts of involuntary manslaughter. It's a rare case. It takes some really egregious facts. It takes the unthinkable. And she has done the unthinkable. And because of that, 4 kids have died. So I'm asking you to go back when you hear the law, review the evidence, and find her guilty, because we have proven her guilty. Thank you.
Thank you.
All righty.
I'm ready to go, and I will, but I'm going to need to use the bathroom halfway through if I start now. Can I have like a 3-minute bathroom break literally?
Do you guys want a break? Okay.
Bump it up.
We'll take about a 5-minute break and then we'll do the cuts.
As the prosecutor finished, she said, "This is shocking, unthinkable." I believe there were other words used throughout trial. Unbelievable. Obviously, unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley. Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, "I've been injured," or "I was failed by the school," even, there will be civil lawsuits, and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up, and the burden has to prove more evidence, and that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at. The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case is that we can all agree everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions. Now, during jury selection, it felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding. And I would suggest to you that at the end of the day, the only judge, although Ms. McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, it's obvious real life is messy and complicated. And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And all I'm saying is that I'm human. I am a human being, and so is Mrs. Crumbley. And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop. So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. Sat on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth on everything, where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that with all kindness because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my way running out the door, putting on my makeup as I drive to court in my car. Because my life is not perfect and no one's is. And during this trial, you may have concluded that you don't like me, that you hate me. That's fine. I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer Crumbley and will judge Jennifer Crumbley's case based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me and supplant them on Mrs. Crumbley. Now, when I took on this case pretty early on, I realized I am Jennifer Crumbley and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years, but that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the text messages that my husband and I exchanged on a daily basis throughout this past year and even years before, it would be so easy for me to be in her seat. With my kids, I don't monitor assignments. I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone I own, but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures? If my son decides he's going to send some pictures back and takes a nude picture of his bits and pieces, that's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl? So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years. So this case is a very dangerous one for parents out there. It just is. And it is one of the first of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist in this matter. Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wygrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together, and subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Maloche testified, another example came about where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does that mean I would be okay if he went and killed a bunch of people and or if he committed suicide? No. Calling your child an oopsie baby was designed to try to make her look bad with no context. Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother-son day with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're going to be doing. It does not mean she loved her son any less if she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I've sent texts to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying. She doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do. I don't know how to handle this. I don't have time for this. My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. The start of a case. My husband works for my office. He's actually my office manager, so he knows about the case. He went in her room and figured out in 5 minutes, it's because when she flips her blow dryer on, one of our plugs makes the lights flicker. So this ghost that you would read about in my text messages, which by the way, I did not respond to, despite the fact that it's on our 6-person group chat, would be taken out of context and make me look like I don't really care that my daughter is crazy. I also got text one day, we have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad we didn't have the right kind of chicken ramen. When we have 85, I like the number 85, when we have 4 other flavors of ramen, and there's about 100 other things she can eat, and I knew she's not going to starve to death, but taken out of context, it makes me look like a neglectful mother. But if you know all the circumstances, and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And when I'm driving home from court every day, I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's drive-through and bring everyone a Coke. I do stop and get myself a Coke, but I am not getting a round of drinks every day for everyone. And I've realized it's easier to not answer the phone. So you can find reasonable doubt from the context that the defense did actually provide. And when Mrs. Crumbley got on the stand and explained to you her understanding of ghosts and dishes flying and laundry flying, that is evidence. And that is something that can create reasonable doubt to hear what was really going on. Even if you believe the prosecution's dates about what was going on, it's not strong evidence. It's very misleading. And I'm going to go through what it does show. There are 3 sets of dates involving Mrs. Crumbley, all from March of 2021. The first time is March 8th and 9th. They introduced exhibits, including text messages on the 8th, where Mrs. Crumbley starts off asking, is he home yet? Is he home yet? I don't want him to do anything stupid. I'm sure you all remember those. Then they introduced evidence on March 9th that she went to the barn that day with her husband on the 9th. Then they introduced evidence, and I will give them credit. They put together quite a case, although it's really not important, that there was a picture of the horse taken at the barn that day, that the data supports there was a picture of the horse taken at the barn that day, and that there was GPS tracking information supporting that she was at the barn that day. Okay, fine. So on March 8th and 9th, there's concern that the shooter, Mrs. Crumbley's son, is making weird comments. And on the 9th, she goes to the barn and she takes some horse pictures. That's all that shows. Pretty minimal. Next, they went to March 16th through 19th, which was broken up into a million exhibits that, quite frankly, were out of order, threw me off my game, helped create these beautiful TikToks. And I'm going to tell you what they show. Now, these ended up all being admitted as exhibits, but I'm going to go in order of what they show. There was a text thread in Exhibit 85, which if you want to look at it, you can, where Jennifer Crumbley said, I'm going to get drunk and ride my horse. This was on March 17th, St. Patrick's Day. A lot of people have a cocktail on St. Patrick's Day. That does not make her a mother that would be negligent or grossly negligent to her child. There's text messages from the day before where Mrs. Crumbley's son is saying some things about, now the house is haunted. Some weird shit just happened, now I'm scared. I got some videos, a picture of a demon. It's throwing bowls. I'm not joking, it fucked up the kitchen. I'm going outside for a while. Can you at least text back? On that day, Mrs. Crumbley didn't text back, but their own exhibit, okay, which is Exhibit 83, so the numbers do bounce around, so we go from 85 to 86 to 83, show that within an hour of the shooter making these ghost comments, she did call him. Specifically, she called him back at 7:24, and they had a 19-second phone call. If it was 19 seconds, it most likely was, I'm on my way home, we'll talk when I get home. So then the state, in order to make it seem like they've really, really got some proof here, they admitted exhibits 87, which show on the 17th on St. Patrick's Day, James was on a horse. They showed People's Exhibit 88, confirming the metadata that James was on a horse. They showed a picture, 89, of Jennifer on a horse that day. Metadata to prove she's on the horse that day. Another picture, number 91, of James on the horse, a different picture. The metadata to prove James is on the horse. A picture of Jennifer with her horse in Exhibit 93. And again, the metadata to support the picture was taken out of the barn and sent, and that these people talked about these horses. Okay, so fine. That's
So
on
let's
the
see here.
17th of March.
Are they
Have
to
access to all-
be? I haven't seen anything from the court, but are they supposedly done for the evening? They're done for the day? 'Cause I haven't got any notification from the courthouse, but that doesn't mean it's not so. Where do I look? Where'd you guys get that info, just so I know? Okay. Law and crime? No, they didn't. That's why I was a little surprised. I'm surprised the courthouse didn't notify us. Usually get something from the court when something like this happens. Okay. Thank you, sweet misery. Thank you very much. So, guys, what we'll do is we'll stop here, and I'll keep my eye on it tomorrow because we also want to take a look at the Adam Montgomery's jury selection. So, what we'll do is we'll just play it by ear as to how we follow through with tomorrow. So, I'll set up Adam Montgomery, and we will watch for an update. So, hey guys, thank you very, very much for spending the day with me. I thought for sure we were going to get something today, but hey, like I said, what the hell do I know? So, guys, have a great night, and I'll see you tomorrow. Bye.